I'm Judge Puffenberger of the Lucas County Probate Court. Today I'm going to talk to you about when you can talk to the judge and when it's improper to talk to the judge. Generally, you may not talk to the judge outside of your hearing. It's important for the courts to present that they are fair and impartial and that everyone is treated the same in a court. And when you talk to the judge outside the presence of the other parties or the other people involved in the case, it's really improper, and it gives a sign that the case is unfair and that that's improper for the court to talk to you, particularly about your case. An ex parte communication is a communication where one party is talking to you and the other is not present. So in a court, the court will only consider evidence that is presented in the courtroom when other parties are there, other counsel is there, and everyone can hear what you have to say. So it's very important that you present your evidence in open court. An ex parte communication is not proper because all sides, when one side communicates with the court, the other side should be aware of what that communication is. That's just fairness. If you have important information for the judge and you're a party, you should present it in court. If you're not a party but you have important information, you should make that known to one of the attorneys for the parties, if you know who they are, and it's on our website, you can see who they are. If you have important information that's favorable or unfavorable to one side or another, you should notify the attorneys so they can consider that evidence and decide whether or not they want to present it. If you decide to send the court, we get letters from people about different issues. I know about what happened here and I want you to know this. You need to know that if you present any correspondence to the court, which we do not encourage, that correspondence will be provided to the opponent, to the other side. It's only fair that they know, if you told something to the court, it's only fair that they know exactly what you communicated to the court. No, there is not. That's the same as an ex parte communication. I could not talk to you privately because I have to be fair and impartial. And once again, you may be telling me things that need to be presented in court, and there are things that the other side should be aware of. So that's highly improper for the court to discuss a case with one of the parties outside the presence of the other parties. Well, if someone tries to contact the court directly with information, that information will be taken down. It will be provided to the other side of the court, but the court will not consider any of that as evidence. That is not evidence. The only evidence the court will consider is what's presented in the courtroom. And so if it's not presented in the courtroom, the court is not going to consider it. So you can send in whatever you want, but if the court doesn't hear that in open court with the other side present, it's not going to be considered. Well, the judge should make sure that the court hears your side of the story and your concerns. That's something the judge should do. The trial should be fair. Each side should be allowed to present their case. And even if you're pro se, you have your attorney, the court will give you ample opportunity to present your case. So that's really a requirement of the court to make sure that all parties have the opportunity to properly present their case. A motion is some paper that's filed in court. It gets file stamped by our court. It should be served upon the opposing counsel. So if you file a motion here, we serve it on the other counsel, you should, or the court, and so they have an opportunity to respond. When you file a motion, the other side always has a chance to respond. And then you may get a chance to reply to their response. So the court would consider those motions and make a ruling on those motions. Motions are generally on issues that are very specific, and sometimes they could finalize a case if they're a motion for summary judgment or something like that. But most motions are ones that the court would rule on prior to the hearing. If you accidentally tell the judge something about your case outside the court then has a responsibility to report that to the other side, that this was presented to you, that someone met with you, someone inadvertently discussed this with you, and then the other opponent, the other side, can determine whether or not they want to file a motion to recuse the judge. Something like that could end up in the judge being taken off the case, and maybe another judge will have to hear the case. So it needs to be made known to the other side, and then they can decide whether they think it's significant enough that they would want to try to do something about that. Ex parte communications apply to not only me as the judge, but also to the magistrates. We have several magistrates in our court, and they are confined by the same rules as the judge. So this every thing I've talked about here about ex parte communications and talking to the judge, that applies to the magistrates also. Well, everyone likes to talk to the judge about their case. I have that quite frequently, but you know, we've always had a sign in my office that says nobody gets to see the wizard, nobody not know how, which is a great movie line. But really, you can't come in and see the judge without the other side being present.